And now, having had access to 375/01/2019, and by access, I'm not saying perusal, I mean the time when you had it, when an order was made that disclosure of that docket should be made available to the defense team in this matter. If you can answer it, you can. If you can't, you can't. Do you know who the suspects are in 375/01/2019?
My Lord, my recollection, and I say this under correction, my recollection, because I want to assist as far as I can, I do know that it will be the people who were inside the house, according to what they allege, and I think Mrs. I don't know whether it's a Miss or Mrs. Piri. That's basically what I recall, my Lord.
Now, at that meeting of the 29th of January 2019, with Brigadier Perumal, the DPP, and yourselves as the investigative team of 636 of 10/2014, what reasons did Makhubo and Buthelezi give for refusing to share that docket with a person appointed by the National Commissioner to come and coordinate 636 of 10 of 2014?
Yeah, my Lord, I do not have a clear verbatim in terms of the response, but all I can say is that there was resistance. It should be noted, my Lord, like I said, before this meeting of the 29th of January, there was already an engagement telephonically between the Brigadier Perumal and the members, and I was told that there was resistance. So meeting there with the DPP and them, things were not really it was a tense situation. Like I said, the Brigadier took exception in terms of protocol and discipline, but there were a lot of issues, my Lord, which I don't think are relevant for this matter, except to say there was a tension, my Lord, and I don't recall the reasons given, my Lord.
And that infighting, that those differences between yourself, Ramohala, Buthelezi, Makhubo, what effect, if any, did it have on the adequacy of investigation and the integrity of investigation of 636-10 of 2014?
Well, my Lord, I wouldn't say it had any negative effect. One will recall, my Lord, that, as I said, at the beginning, it was a fact-finding type of a mission. It wasn't, the misunderstanding or the difference of opinion was not insofar as whether there is evidence to link, for example, accused 1 or accused 2 or any of these accused. It was really to dissect and see whether the docket, in terms of what is contained in the docket, not what someone is wishing, my Lord, or what allegations are saying, whether the docket, in terms of the evidence contained in the docket, suggests indeed that there were no intruders or there were intruders. So the difference of opinion was insofar as that part, and that is where we walked our separate ways, my Lord. So insofar as the investigations that led to the site of these accused and eventually their arrest and the processes that followed, my Lord, there was no issues or integrity or even a desire to say we simply followed. And I'm talking about me now, my Lord, because I was now leading the team without the two members. We simply followed the evidence and were guided by what was available at the time. We collected whatever we needed to collect, my Lord, within the prescript of the law. So there was nothing that was done out of those boundaries.
Now, just reverting to docket 375 of 01/2019, I know that it's got nothing to do with you, but the question is this. Are you aware that the DPP has yet to take or make a decision on whether or not to prosecute that docket?
As a good place, my Lord, I don't think that is correct. There is a letter to that effect. The DPP has made a decision, and his decision is to hold over a final decision pending the outcome of this matter.
Yes. As a court places, my Lord, I do take the response by my learned colleague. If I may, for contextual purposes, my Lord, refer the witness to Exhibit Q, which is a directive or correspondence from the DPP dated the 26th of October 2022, and this correspondence was addressed to the erstwhile advocate of all the accused persons before court, Advocate M.D. Tefo, and this is an exhibit of this court, my Lord. And I'm not sure whether the contents thereof have been placed on record, but in line with Mafaledi's case, my lord, I'll do so here. And it reads, the addressee, like I say, it's Advocate therefore, and the CC is Mr. Toban, who was the instructing attorney in this matter. And it says, dear sir, Ray Foslora's case 375 of 01-2019, S. versus Sibia and 4 others, CC 67 of 2020. Paragraph 1 thereof, it reads, the National Director of Public Prosecutions has issued an amended directive on the 22nd of August 2022 in terms of Section 22, subsection 3 of the National Prosecuting Authority Act 32 of 1998, read with Section 111 of the Criminal Procedure Act 51 of 1977, and also transferring jurisdiction in respect of Foslora's case 375 of 01-2019 from the area of jurisdiction of the Director of Public Prosecutions, Johannesburg, to the area of jurisdiction of the Director of Public Prosecutions, Gauteng Division, Pretoria. The amended directive will be handed up in court. Paragraph 2 thereof, this office is therefore mandated to make a decision in respect of Foslora's case 375 of 01-2019. Paragraph 3 thereof, in the light of the fact that the decision in Foslora's case 375 of 01-2019 depends on the credibility findings by the trial court in the current trial involving Foslora's case 63610 of 2014, I have therefore decided that the decision in Foslora's case 375 of 01-2019 will be made at the conclusion of the current trial. It is thus signed by the DPP of Pretoria, Gauteng Division, Mr. S. Mzinyati.
Yes, my lord, I'm aware of this letter.
My lord, just to correct myself, Advocate for at the time represented only accused 1 to 4, not all of them, my lord.
As a court, please, my lord, just a correction. Exhibit Q, it's a letter addressed to Advocate Mshololo. It's exactly the same letter, but it is a letter addressed to Advocate Mshololo. This one addressed to Mr. Tifo was not handed up as an exhibit.
Yes, sorry, my lord, because the one that I have, and it may have been an error on my part, is the one that's addressed to Advocate Tifo. I did not have the one that was addressed to Advocate Mshololo, but the essence is that the contents are the same, my lord.
Yeah.
They mirror each other, my lord, to the T. Now, the point that I was emphasizing was that this decision in respect of 375, for the people that you say are the people that were in the house essentially, including Maggie Piri, will be made based on the credibility findings made by this court in this matter regarding 375.
Correct, my lord, but it is insofar as the charge of defeating the end of justice, not the murder of Senzo, because the docket is very clear. It's defeating charge, my lord.
Yes. If I may get an opportunity to get my bearings on my notes. Okay. Now, before I go to the reasons, because during your evidence in chief, you mentioned several reasons why you say that you and Ramohala believe that there were intruders in the house on the 26th of October 2014 that perpetrated the offense that occurred there, correct?
Well, partly correct, my lord, in that the reasons I gave in, those were my reasons. Yes. I analyzed, like I've said, everyone was given an opportunity to read the docket independently. So Ramohala's views come in a sense that he was also of the view that there were people who came into the house, but I did not put it in a context that, my lord, this is what he found, the way I found it. I was simply putting my reasons to say, what is it that convinced me that they were intruders?
Now, you testified that before coming to this belief that there were intruders, your initial belief as well was that there were no intruders. Am I quoting you correctly?
Yes, you're quoting me correct, but I also qualified it, my lord. I think when I was asked by Advocate Baloyi as to where was it coming from, and I said, basically from what I was briefed, it was not based on facts, it was not factual. When I read the docket, that's when I was able to make a decision based on the facts that were contained on the docket, my lord.
And to that extent, I'm not talking about this belief from your part initially that there were no intruders. You made a statement to that effect, is that correct?
I don't think I made a statement, my lord. Right. I think if Mr. Ramsipula said I made one, he can tell me. I don't recall. It was just a thought, like I said, when then, I don't have a recollection of that statement, my lord.
To be fair to you, the statement is not explicit to state that there were no intruders, but you deposed to a statement on the 19th of November 2020 at the NACOM National Commissioner's Pretoria office. The statement was commissioned by Dowelani Dion Molaudzi, who's a detective sergeant, and yes, it was deposed to, it was commissioned on the 23rd of November 2020 at 15:30 in the afternoon.
My lord, if it was made in November 2020, I doubt very much if I would have said or created an insinuation that there were no intruders, because if one looks at that date, the matter was already enrolled. In other words, this matter was enrolled on the 26th of October 2020. My recollection, and I think Mr. Ramsipula can refer me to the index number, I'll get to that statement, but I have an idea what he's talking about. The statement I made in November, my lord, relates to further investigation and the evidence I collected insofar as my request in pursuance, or rather my application to have Kelly Khumalo charged. I think that is the statement. It pertains to that because I talked to the evidence that I've collected. What is it that I think implicates her in addition to the confessions? And I think I will talk to the issues of the numbers that were not disclosed. So that statement that I made in November, it is insofar as the application to the DPP to say Miss Kelly Khumalo should be charged, as he acted as a trigger point. That's my recollection. I don't think I would have said there were no intruders, my lord. Yes, my lord. So in November, my lord, if I can just assist the court, in November, there's a statement I made on the 20th of November 2020, and at no way would I say there were no intruders. And then the next one, like I said, unless Mr. Ramsipula can specifically refer me to it, the next one in November.
The one that I referred to, and let me give you the date and then just give a bit of a background of my understanding, but I want us to go to this statement.
Yes, what is the index number, Mr. Ramsipula?
I don't know what the index number is. On top it says A225.
Yes, that's the one I have in front of me, with five pages.
It's got, now the one that I have is got 4 pages.
No, A225, it's 5 pages. So you have 105, it goes.
Mine has got 4 pages and the paragraphs, 1, 2, 3, 4, and the paragraphs are sequential until the end, so it cannot be that one.
Is it with 5 paragraphs?
Yeah, it's a big paragraphs, 5 paragraphs.
Yes, that's the one that I have, and that's the evidence. But let me hear you, Mr. Ramsipula. Yes, but I have it.
Just hear me out, and
yes.
And you are indeed correct. Let me give you that regarding the context within which this statement was made. That it was in relation to an application for a Section 43 application, CPA, J50 warrant of arrest in respect of Miss Kelly Khumalo. But
yes,
I want to go through this with you and put certain questions to you.
Yes.
And this one, because it's typed out, I can read myself. My
yes.
Lord, I've already put the commissioning part on record that it was commissioned by Detective Sergeant Molaudzi, but mine is dated differently, my Lord. It's dated the 19th of November 2020 at 1500, and the commissioning happens on the 23rd of November 2020 at 15:30. And with leave of the court, my Lord, may I read this statement on record. Paragraph 1 thereof, it states, I am employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same act. I'm currently stationed at the National Commissioner's Office as the commander of the cold case unit of the National Commissioner with rank of Colonel and service number with telephone number. I'm the leading investigating officer of Fosloras Case 636 of 10/2014, which is a murder case where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100. The deceased was shot at a house belonging to his girlfriend, namely Kelly Khumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that the two black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the accused was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second suspect. The second suspect was described as tall, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gun shots hit the deceased Senzo Meyiwa on close range in his chest and exited at the back of his body. The second accused focused on the rest of the witnesses, and in the process, one cellular phone belonging to Miss Kelly Khumalo was robbed by the suspects during the committal of the offense. It is also stated under oath that suspicious suspects wearing specific clothing, amongst others a hoodie, were standing hidden but only a few meters from the crime scene prior to the incident, appearing to be typing on their cell phones. It is stated that the suspect fled on foot and a hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspects hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identity kits were compiled through witnesses of these suspects. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 20:30 and 2100. The deceased was declared dead on arrival at the hospital at 2115. Paragraph 3. Investigations revealed that the cell phone which was robbed was picked up through cell phone towers until signal was lost, covering the area of Fosloras Hostel. The said phone was never recovered to date or ever switched on again. The evidence explained herein under would indicate that the planning of the offense and gathering after the incident took place at Fosloras Hostel. Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or a robbery gone wrong. Evidence under oath revealed that 6 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa at the directive of Kelly Khumalo. This suspect, in brackets, Nonhlanhla Kelly Khumalo, is first linked by means of confessions that were made by both accused number 1 and 2, as they both implicate her as the person that gave the instructions to kill Senzo Meyiwa. Investigations further revealed that she had 4 other cell numbers that she did not disclose to the police when these incidents took place. The numbers are as follows: 079 bullet point number 1, 079 494 8773. Bullet point number 2, 073 451 50 Bullet point number 3, 073 388 6730. And the last bullet point, 061 456 2104. Investigations further reveal that she is linked to the actual perpetrators of this murder by means of cell phone linkages. These linkages connect her to accused 3 and 5. It was further discovered that through cell phone analysis that her cell phone memory has the same photo of a see-through bag containing cash notes and in the exact position, location and spot as the one of accused 3. Longwetwala has the same bag of money. There is no reasonable explanation as to why Kelly Khumalo will be in contact telephonically with hitmen of her boyfriend. There is also communication records between her and her sister shows that as early as 2013, she wanted to get rid of the deceased, as she puts it clearly on the WhatsApp messages. It is abundantly clear that she hated him and wanted to get rid of him. She further states that she regrets not succeeding to get rid of him before. Taking into account all of these facts, an inference can be drawn that she meant killing him. Paragraph 4. Evidence by means of sworn, corroborating, and independent witness statements establish a causal link between the offenders and the offenses of murder, robbery with aggravating circumstances, possession of unlicensed firearms, and the unlawful possession of ammunition, and conspiracy to commit murder. Miss Kelly Khumalo seems to be the trigger point of this offense. I hereby apply for the warrant of arrest for Nonhlanhla Kelly Khumalo on charges of conspiracy to commit murder and murder. Paragraph 5 is the taking of the oath. It is not signed by yourself and commissioned by the commissioner who I have mentioned before, Detective Sergeant Mulawuti.
Yes, my lord.
It's highlighted. Thank you, Mr. Jonas. Now, Brigadier, I want us to go back to the statement and I want to put certain questions to you. Before I do you still maintain the truthfulness of this statement?
Yes, I do, my lord.
Now, at paragraph 2, where it says, it initially appeared to be that it was a robbery gone wrong. Can you elaborate on that?
Yes, my lord. If one looks at the statement, and I think I dealt with this part, that when I was doing the analysis stage, but this analysis was based on what is contained on the docket. Statements of the people who were in the house are clearly indicating that the perpetrators, the alleged perpetrators who came in, demanded cell phones and money. There was no indication, if you look in those statements, that there was an intention, there was a contractual arrangement to eliminate the deceased, my lord. It was an issue of a robbery that would have went wrong, and subsequently the deceased was shot. That assertion in paragraph 2, I base it on the facts that are contained in the statements disposed by the people who were inside the house, my lord.
And where it says 7 adults and 1 child were present in the house when the accused entered. In hindsight, now that we know, how many kids were in the house?
My lord, at the time, I thought there was 1, but I do know that it was brought to my attention that there were 2 children. So the adults includes the deceased, but the children, which I did not confirm, but it was brought to my attention that there may have been another child belonging either to Miss Kelly Khumalo. I'm not so sure, but there was make mention of a second child, my lord. But personally, I have not independently confirmed that, my lord.